Let's start off with just a couple basic concepts. The rulemaking authority for the Supreme Court is vested in the state constitution of 1947. There's a specific grant of authority in our Constitution which permits the Supreme Court to promulgate rules for the administration of justice in our state. Now, what the court has done since 1947 is nominate and maintain a variety of advisory committees made up of attorneys who are familiar with this particular area of practice and can advise the court on necessary changes to the rules. For our purposes, we're going to be talking about two of those committees this evening, the Municipal Court Practice Committee and the Criminal Practice Committee. The various committees that are advisory to the court for rules have a staggered schedule. That way the court is not overwhelmed with a bunch of reports from the committees all the time. So the schedule for the Criminal Practice Committee and the Municipal Practice Committee run in tandem. It's every 2 years. They're on a 2-year cycle, so this was their year to submit a report to the court. These reports are, of course, scrutinized by the court. Sometimes the court will adopt everything in the report. Many times, though, they'll reject certain of the provisions. Sometimes they'll take the request by the committee, their recommendations, and modify them to a certain extent. And every once in a while, as you'll see that happen this year, the court will come out of the blue with their own court rule and just put it in the rules, even though nobody was even asking for it. It just it's a creature that comes from the justices themselves. Now, let's just talk practically where these rule changes come from, because there are different ways they get from the clouds, so to speak, into the published rules. First of all, very often the source of the rules comes from case law. And the case law can be something that happened immediately. In other words, the case is published, and right away it sparks a change in the court rules. Often you'll see that there's a long period of time as cases develop over decades, which finally there gets to be a critical mass and the Supreme Court will authorize a change in the law. And we'll see an example of that where the history of this rule actually goes back 25 years and finally culminated in the amendment. On occasion, the suggestion for a rule change will come from one of the members of one of the committees, and they just make up something they think will help the practice around the state, and you'll see that here. Sometimes also there'll be rules promulgated in response to legislative action, and you'll see that on this occasion as well, that a statute was enacted and required a change in the rules, okay? So we'll kind of go through these things to make sure that you understand what the background is. My idea being that when you get up in court to argue various points related to the rules of court, that you can do so in a much deeper context. State versus Storm. And Storm, as you all recall, the 1995 landmark decision by our Supreme Court dealing with the issue of who may appear on behalf of the state of New Jersey in municipal court. As you remember, prior to this time, it was not uncommon to have private attorneys going in and representing private litigants in the municipal court context, a practice that apparently had gone back to colonial times in our state. And it was something that was extremely unpopular with our Supreme Court. And in subsequent cases where they've discussed this issue, they mention it as a disfavored type practice, either in the body of their case law or in the footnotes. So they're still not particularly happy with it, but it's out there. The Storm case really created one substantive and one procedural component to the law. The substantive component was that it's going to limit the ability of an individual to appear on behalf of the state of New Jersey in municipal court to those circumstances where there's cross complaints. So typically it'll be, boyfriend, girlfriend. There may be a domestic violence component against the boyfriend, for example. He will turn around and sign a complaint alleging simple assault or something against the girlfriend. Winds up in municipal court, and the prosecutor really has a situation now where he's kind of in a conflict because, he either has to decide which is the guilty of the two parties or puts himself in a situation where he's got to prosecute both of them, and you have all kinds of issues with respect to right to remain silent and things of that nature. So it makes it easier on many occasions to have a private prosecutor coming in and prosecuting one side of the case, and the public prosecutor, or sometimes two private prosecutors, prosecuting the other side. So in order to avoid the danger of conflicts, this is why the Supreme Court permitted these private prosecutors, but in this one limited circumstance dealing with cross complaints. So, for example, the old practice of having a private prosecutor come in and prosecute all the shoplifting complaints on behalf of a big box retailer, that's out. That can't happen now because there's no conflict there. It's not a cross complaint type situation, not permitted. Now, the procedural change dealt with the so-called storm certification that attorneys who want to appear on behalf of the state of New Jersey in the cross-complaint case have to complete. And, of course, you're all familiar with the form. It was promulgated by the Administrative Office of the Courts and basically makes you certify that you don't have any conflicts, and then you'll behave yourself and do what prosecutors are supposed to do, okay? Once you submit this to the court, the judge can then make a determination as to whether to admit you as prosecutor, and if the judge, in reviewing the storm certification, finds that it would be in the interest of justice to have you there you are. The holding in the storm decision was codified to a certain extent under Rule 7:8-7, and you can see from reading the rule over, it is limited to cases involving cross-complaints. Now, the background to these cases deals with amendments you're going to see in a moment to Rule 777. 7:7-7 is the general discovery rule, and you'll see in a few moments that the rule is, there's technical amendments that are going to be made now to reflect this practice under State v. Storm of private prosecutors on occasion appearing on behalf of the state of New Jersey, and what the responsibility of these individuals are with respect to providing discovery when it's demanded. The next thing you'll need to know about on 777 amendments is the statute, which is 2B25-4A. This is the statute that requires now that every municipality in the state have a public prosecutor to appear on behalf of the state of New Jersey. Many times the municipalities either didn't have a prosecutor at all or would have a prosecutor who had very limited responsibilities. In other words, his responsibilities by ordinance may be prosecute the cases that are signed by our local department. So private citizen complaints, state police complaints, all those, they were kind of on their own. And the prosecuting of drunk driving cases by state police officers was not an uncommon phenomenon around the state. In the general ongoing desire to enhance the professionalism of the municipal courts around our state, the legislature enacted Title 2B, Chapter 25, and again, this requires a prosecutor be in every municipality around the state. You're going to see a technical amendment as a result of that. Now, the major change that came about in Rule 777 was 25 years in the making, dealing with not only the entitlement to discovery, but the scope of the discovery that you can receive. The beginning of this case was in State v. Pulaski back in 1986, a decision written by Martin Haynes, who at that time was the assignment judge in Burlington County.
We're going to see in most of the cases that we're going to be discussing tonight, the cases themselves are very simplistic, careless drivings, speeding tickets, but the results of what happened as a result of the cases is what's really important. Here, a very simple case, apparently a two-car accident, careless driving being the most serious charge of the two issued to the defendant. And then this one, the defendant's attorney just wrote a standard letter of discovery to the prosecutor. As a result of writing that, he actually got a call from the court clerk and was told that he would not be receiving any discovery. He followed up that letter with a second request, and as part of that indicated, I'm coming for the trial. And on the night of the trial, if I don't have my discovery, I'm asking for dismissal. The attorney believed there was some sort of information in the police report, namely maybe some witnesses that he would like to either subpoena to be at the trial or at least speak to before the hearing date so he could determine whether there's anything there to help his client. The matter came to the point of the trial. The attorney still didn't have discovery. He made his motion before the municipal court judge to dismiss, which was denied, and then it went up to Judge Haynes in the law division of the Superior Court. Judge Haynes did a rather exhaustive study of the idea of a 39-497 and what the penalties could be. So he looked at the charge itself, 39-497, looked at 39-4104, he looked at 39-530 and 31 in terms of what could happen. And Judge Haynes determined that this was 39-497, a consequence of magnitude. He didn't buy the prosecutor's statement that the idea that any kind of penalties here, such as imprisonment or loss of license, were remote. He says it doesn't matter, remote or not, it's still a consequence of magnitude, and therefore discovery is required to be given to the defense counsel.